Okay, good afternoon, everybody. My name is Ron Ness, President of the North Dakota Petroleum Council. We've got a great session today. Our NDPC speaker series, we had a safety meeting about a month ago, and we had a very large crowd of safety experts. And we had the WSI show up, and we had a lot of great questions about contractor versus employee liability. And this has been something that's come up in our One Basin, One Way program as well. So thank you for joining us, taking time out of your busy day. This is something that I am, in a previous life, 25 years ago, I was the Deputy Commissioner of Labor. So I may recall about enough of it to be dangerous, but I do very vividly recall the 20-point common law test that North Dakota uses that Sarah will be going over today. So we're going to ask everybody to mute their phones, and if you're not a speaker, turn off your camera. We'll use the chat session. We've done a lot of these, and sending your questions into that chat area works extremely well. We've got time built in because this is all about getting you the questions answered that you have today. Very, very important topic, and something that I think is extremely serious when it comes down to doing it right or not doing it right. The ramifications can be high. So we've got a great group of experts along with us today for provide the background on the topics from a state versus a federal level, which are very unique. And as employers, you have to be aware of all of those things. So with no further ado, Pat Nicodemus is a guy that's been around the insurance industry a long, long time, done a tremendous amount of business in North Dakota for, I think, about 30 years. Pat and the Petroleum Council formed an endorsed program for insurance and risk management a few years ago. And AssuredPartners has carried that forward. So we rely on Pat to provide our members with their insurance needs and or their risk management needs. So welcome, Pat.
Thanks, Ron. And thank you for everybody for attending, and thank you to the speakers. I'm very excited to hear the presentation today. So I will not be on here very long. I will let the adults take over once I'm done. And but I did want to say, when you and I started this program 2 years ago, our goal was not only to help lower premiums for the NDPC members, but also to be a source of information and guidance when it came to certain issues that are unique to the oil field. And this one is probably one of the most complex, as you'll see with the next three speakers, how difficult and complex it is. Like I said, I will not be speaking for long. I just wanted to touch base on a parallel issue that is once these guys scare you with problems you can run into and the issues between employees and subcontractors. You know, I was thinking about it, Ron. I started writing insurance in the oil field in the late 90s, and I think at that time there was less than a handful of operators or producers that required master service agreements. It was, you know, Marathon and all the bigs. Probably today it's universally understood that if you're going to go work for any oil company today, you're going to sign a master service agreement. And the reason that they put those things in place is it spells out the relationship between the operator and the service company. So it specifically defines in the contract who is the operator and who is the independent subcontractor. So there is no problem with the status of contractual participant. The other thing that the master service agreement does is it indicates the limits of insurance that are required, your duties in the case of an incident, and also who is indemnifying who. Operators use these all the time. The issue that we run into is not a lot of the service companies use subcontracting agreements for the companies that they subcontract to. And that's one of the biggest issues, one of the things that we work on, Tara and I and Pat work on the most, to make sure that the contractual transfer of risk is probably the easiest to implement, the most cost effective, and it is the most effective in any type of litigation, more so than an insurance policy. So if you have subcontracts in place, you have to know that every time your master service agreement changes with the operators that you're working for, you need to make sure that your subcontract agreement is also changing as far as terms limits or obligations. And we spend a lot of resources tracking that for our insureds. And if you're not doing that, you could be opening yourself up to unwanted obligations as far as coverage problems, gaps in coverage, limitation problems, or whatever. So anyway, that's my 10 cents for the day. I'm very much looking forward to Tara is one of the best loss control safety people that I've ever worked with. She and I work on a daily basis. Pat is an unbelievable resource for us. He's probably one of the top Osha attorneys in the country. And I'm looking forward to Sarah's presentation today. I've heard nothing but good things from her presentation on at the safety meeting in Bismarck a while ago. So with that, I'm going to pass it over to Tara, and she can take over. Thank you.
There we go. Sorry, I was muted. So hopefully you guys are seeing the screen. As Pat said, we just have a couple of points that we wanted to hit from an insurance standpoint. When you talk about those master service agreements, it's definitely something that our carriers are very interested in knowing about and understanding. So when you're doing a loss control visit with your insurance carrier, or if you're working with your broker and you're shopping for some insurance, one of the big questions they're going to ask is if you have MSAs in place. And we want to make sure that you have those MSAs reviewed. And again, that's something that our office partners with an attorney who specializes in oil and gas to take a look at those MSAs. The thing that I wanted to touch on, because, Sarah's going to get into this in more detail, and then Pat's really going to dive in on the OSHA side of this, is my favorite line in my office is OSHA doesn't care about your MSA. And I think Pat Miller will agree with that. If OSHA's coming on site, it doesn't matter if you have an MSA in place. They're going to be looking at some other items to determine whether this is an employee or a contractor, and who's protected in those cases. And Pat Miller is going to go into that. Some of our carriers insist on having a declaration of independent contractor status signed and available. But truly, those written agreements stating that worker is an independent contractor, they're typically insufficient to qualify the worker as an independent contractor. And so, again, just something I want to point out, your carrier may ask you to do it. There's not a problem with doing it. And again, Sarah's going to get into that as well. Another issue that we've run into recently from a workers' compensation contractor and undocumented employees is, again, advising and making sure that everyone is doing those employment status checks, those I-9 checks, because depending on the state, and again, just like work comp, these status change from state to state on how states handle undocumented employees and workers' compensation. And then the other concern that we started to see, because again, our customers are looking at, any way that they can save money. And one of the most costly things that your business does or has is insurance, usually second only to payroll costs. And so you're looking at ways to reduce those insurance costs. What we started to see is a bit of a trend where we have contractors, or yet those independent, they're not independent contractors, they're employees, but the employer has determined, hey, if we have these employees use their own personal vehicle on company business, we can save some money on our automobile insurance. And what we're running into is they maybe haven't thought that all the way through, and now they may be in violation of their MSA for the operator. So before you, get to talking amongst yourselves and say, oh yeah, that's a really good idea, we could save a lot of money on insurance, be aware that you may be in violation of your MSA. And again, those are services that AssuredPartners can provide as your broker to support your risk management efforts. So Ron, I'll turn it back over to you to introduce the next speaker.
Thanks, Tara. And I think the focus of the day is not that there are not independent contractors out there. I think the focus is for everybody to know that the set of standards and rules and things that they should be looking for, and the hot buttons, and just really the common sense test as opposed to the common law test. So with that, workforce safety and insurance is a fantastic partner of ours. Oil and gas has 6 subclasses of worker compensation rates. We're the largest premium payer of all the various rate classes of the oil and gas industry. We partner with them on our Safety One Basin One Way program. So we're very glad to have them here today. Sarah Feist is the Director of Policyholder Services. Sarah's going to go over the basic rules of contractor versus employee. Welcome, Sarah.
Hi, thank you, Ron. Yeah, Workforce Safety and Insurance is extremely excited to be here to have the opportunity to present today, in regards to this discussion point. So WSI continues to have the lowest workers' compensation rates in the nation, and for the last 10 years has been able to return a 50% dividend to our employer base. We currently administer 25,000 employer accounts and continue to see a steady decrease in the number of reported injuries each year. In 2012, to Ron's mention of the 6 primary oil field classification codes, currently in 2012, it comprised just under $1.9 billion in total reported payroll for the agency. And in 2015, we saw that top over $4 billion. That's more than double in just 3 short years of business. In 2016, we've continued to see a steady number holding true at 2.5 billion in reported payroll to Workforce Safety and Insurance. Now that's just reported payroll to WSI. That doesn't include any payments made to contractors. The topic of contractors versus employees is a really important issue. This is something at WSI that we review almost on a daily basis. In oil and gas, WSI understands that the use of contractors is an immediate solution to all of you in an unpredictable market where you need skilled workers who can set up at a moment's notice to keep business going. However, there's some disadvantages as well. So Sarah Cody, our compliance officer and underwriting supervisor today, is going to be presenting. She's going to cover the items that are considered to be associated risks of misclassification for workers related to workers' compensation insurance in the state of North Dakota.
Thanks, Sarah. I do have some great information to go over with you today regarding items to take into consideration when you're thinking about those relationships and considering whether or not those workers are independent contractors or employees. Also, some things to think about and what happens if those workers are misclassified and how it can affect you or your business. So it's important to understand the coverage that WSI provides in order to appreciate why workers' classification is so important. And in North Dakota, WSI is the sole provider and administrator of the workers' compensation system. We are a no-fault system providing coverage for workplace injuries, illness, and death. And it's important to note that all account holders are equally insured and coverage is provided without limits other than those limits that are placed on individual benefits, such as your weekly disability benefits paid to individual workers. So that I know is different than what you see in the MSAs where they require you to set different limits or coverage levels. With your WSI policy, again, coverage is provided without limits and everyone is equally insured. And also, we don't issue a policy. Rather, all provisions and forms are found in Title 65 of the North Dakota Century Code and Title 92 of Admin Rules. Now, if you only remember one piece of information or one slide I have today, please let this slide be the one. I repeat and talk about the presumption of employment over and over and over throughout every day that I'm working. And what the presumption of employment is, this comes from Title 65 of the North Dakota Century Code. But what it says is that each individual who performs service for another for remuneration is presumed to be an employee of the person for which the services are performed, unless it is proven that the individual is an independent contractor. It's the burden of the person asserting independent contractor status to prove that fact. So to break that down and to simplify that a little bit, each individual who's doing work for somebody else for any exchange of goods for services, they're automatically presumed to be an employee until proven to be independent. So again, just keep that presumption of employment in the back of your mind when thinking about those relationships between hiring firms and workers.
All right, folks.
Now, worker classification, it affects a lot more than just workers' compensation. Misclassified workers can be denied access to benefits such as minimum wage, overtime, unemployment, as well as workers' compensation. WSI, the Department of Labor, and Job Service, we all utilize the same 20-factor common law test. Osha uses the Darden Factors and the IRS uses the right to control test. And each agency has their own set of criteria or factors that they apply when making their determinations. And not all tests are exactly the same. They may vary slightly. And each individual agency is going to want to do their own reviews just because there are some slight variations. And at WSI, our core purpose is to care for injured workers. So if the outcome of the review is that an employer-employee relationship exists, what that means to a business or a hiring firm is that they're required to have workers' compensation coverage, maintain an employer account with WSI, and pay premiums for those workers. So in the event there's a work-related injury, that worker is eligible for workers' compensation benefits. And that would include your medical benefits, pharmacy benefits, wage replacement, return to work services, and even funeral benefits. Now, the way those requests are received, they can come about through a variety of methods. They can be internal requests or external requests. We could have a claim for benefits or a premium audit review. Requests can come from even the workers themselves or a hiring firm. But regardless of how the review is initiated, once that request is received, there is a formal process in place that applies to all reviews. And what that consists of is sending out questionnaires in order to obtain information necessary to apply that 20-factor common law test. And when we're looking at that 20-factor common law test, when we're making the initial analysis, it's based on the more weighted factors. And while the intent of that relationship may be that the worker is independent and there may be contracts in place, it's how that relationship actually functions that's taken into consideration when WSI is making that determination. So to perform the review, questionnaires are sent out to a hiring firm and workers, contracts and any other information that's provided by the workers and hiring firm is reviewed, and then an analysis is prepared. And that analysis is prepared based on the more weighted factors. And unfortunately, if there's no participation, if there's no response or very little information is provided, remember that slide we talked about with the presumption of employment? Well, based on the presumption, the worker is already presumed to be an employee. So if somebody is taking this process and they're in the independent contractor review world, going through a review, it's best to provide as much information as possible so that we can apply the more weighted factors appropriately. And of those more weighted factors, the first of those I'd like to discuss is integration. Integration meaning the success or continuation of the business is depending upon the service provided by that worker. An easy example that we could all relate to with this would be to think of a convenience store. With a convenience store, you have a clerk who works behind the counter and may run the gas pumps and helps those customers check out and pay for their purchases. And that's a really important, necessary part of the operation of that business. However, if you take that same convenience store and you have the fountain pop machine that breaks down, and there's an individual that comes in to repair that machine, well, that individual coming in to repair that machine, the service they're providing is not necessary to the function of that convenience store to continue to operate and be successful. So that's just an example of integration. Also, integration also shows that the person who's providing the services, that they're subject to direction and control by that hiring firm. Another of the more weighted factors is a continuing relationship. So a continuing relationship indicates an employer-employee relationship. Even if the work being provided by that worker is at irregular intervals, then there can still be an employer-employee relationship. So if there's an expectation of continuing work at the end of a project, somebody's working a rotational shift, for example, 2 weeks on, 2 weeks off, that sort of thing, that would be viewed as a continuing relationship, and that would be indicative of an employer-employee relationship. Now, if that work was performed for a finite period of time, there's a contract in place, the work is to be performed from this date to this date, that would be more in line with an independent contractor relationship. Another of the factors is significant investment. Now, this would be an investment above and beyond what is typically required of any worker performing a service. And for example, I have been performing these reviews for about 6 years now, and a response I very frequently hear with regard to significant investment is that the worker provides their own vehicle to get to work and that they pay for their own gas. Well, as we can all relate, most of us have to provide a vehicle to get to and from our job and also pay for our own gas. So that in and of itself would not be indicative of an independent contractor relationship. Now, if you apply that same philosophy to vehicles and getting to and from work to a welder, if you think about all the specialized modifications that welder has to do or does to their vehicle so that it can, bring their equipment with them and it's set up and ready to go, that's much more in line with a truly significant investment when you compare it to a worker who's just paying for their own gas to get to and from work. Another more weighted factor is a realization of profit or risk of loss. And the risk of loss that a person doesn't receive payment because they simply didn't show up for work that day, that would not be considered in a review that's a true risk of loss. Now, if somebody turned a wrong valve and caused a lot of damage or caused an incident to occur and they are personally responsible and their insurance is responsible to pay for any damages that occurred from their actions, that is a bona fide risk of loss. So that would be more indicative of an independent contractor relationship. And continuing on with the more weighted factors, working for more than one firm at a time. So if an individual is providing the same service to multiple hiring firms or businesses at the same time, that's more in line with an independent contractor type relationship. If that worker is making the service available to the general public through social media, advertising, all of those sorts of things, that would be indicative of an independent contractor. The right to dismiss a worker or the right for that worker to terminate services at any time without either party incurring a liability for breach of contract. That's something that's looked at again in determining if the worker is an independent contractor or an employee. If there's no liability on either party, if that worker is terminated or if that worker doesn't show up for work, that would be that independent contractor type relation. That would be an employer-employee relationship. Now, while we do rely more heavily on the weighted factors when making our initial determination and analysis, it doesn't mean that we don't pay attention to or don't use the other factors. We rely on our legal counsel to make the arguments for those other factors if that review would escalate to a legal matter. Now, some of these additional factors include training. Are the services rendered personally? Can the worker hire, supervise, and pay assistance? Another one I'd like to point out is that worker doing work on the premises of the person for whom the services are performed? So it's not necessary. In the oil and gas industry, it's standard for example, a servicing company to have workers who go out onto someone else's job site. That work is not always going to be performed at the servicing company site, but simply that worker working off-site on someone else's location, that doesn't mean the hiring firm doesn't still have the right to control the worker. So even though the worker is performing services at somebody else's site or job site, simply the hiring firm having the ability to control them, that would be indicative of an employer-employee relationship. Now, what you don't see here and you don't see in the more weighted factors is the worker paid on a 1099. That doesn't appear anywhere in the 20-factor common law test that we're reviewing, but it's something that I hear as the sole argument over and over and over again as to why a worker is an independent contractor. So while we may ask what form is being used to report that worker's income, it's not a factor used in the 20-factor common law test. So even when the intent is an independent contractor relationships and contracts have been signed, it's important to know that what's contained in that contract doesn't supersede what the law says. So there's a specific section in Title 65 that outlines no agreement by an employee to waive their rights to compensation is valid. So that's just something to be mindful of, that that's what Title 65 and that's what the North Dakota law says regarding workers' compensation. So once a determination is made, a formal appealable decision is then issued to the hiring firm and workers. And now, as you can see from the steps that I have listed here, taking into consideration 2 45-day appeal periods and 3 separate courts processes, that these files can take quite some time to bring to completion. Know that if you're part of this process, it's not an overnight, process. We don't look at it, determine employer, employee, or independent contractor, and boom, it's done and final. So there is an appeal process. That appeal process is open to both the workers and the hiring firm. But if those appeals are submitted, it does take some time to bring that to a conclusion. So I've laid out the factors used in determining if a worker is independent or if they're employee. The outcome of those reviews is that a business either does or does not have a requirement of workers' compensation coverage, and premium and penalties, if they apply, are billed accordingly. So finding out you owe back premium and penalties, if those workers are found to be employees, can obviously have a financial impact on your business. And another section of Title 65 to be mindful of, and that can have a pretty big impact, is general contractor liability. And what this section of statute says is that a general contractor and a subcontractor are liable for payment of premium and penalties owed by a subcontractor or independent contractor that does not secure the required coverage or pay the premium owing. So the practical application of this would be a business subcontracted work to an uninsured subcontractor who then either would not comply by either paying the premiums that are billed to them or by not securing the coverage that was required of them. Now, if this circumstance happens, what the trickle-down effect is, or what happens next, is WSI, once they determine who was subcontracting the work to that subcontractor, they would begin to request information regarding payments that were made to that business, the amount of work that was performed, and notifying you that that subcontractor is uninsured, because if that sub refuses to come into compliance, then WSI would issue a notice of decision to that contractor or another business who had subcontracted work to the subcontractor. Now, there are various penalties that are outlined within Title 65, but of those penalties, a few that I want to point out and just make sure that you're aware of are the costs and reserves of an uninsured claim. So what statute says is that the costs and reserves are monies that's set aside to pay for that claim, those are actually billed back in the form of a penalty to an uninsured employer. So if you think about medical costs, wage replacement, all of those different coverages I mentioned that are included with workers' compensation, if those are billed back to your business, if you were uninsured, then that can obviously have a significant impact on your business operations. And that definitely is not the time that you want to find out about North Dakota coverage requirements. Also, standard noncompliance can be billed up to 6 years in the past. So if it's determined that a hiring firm had a requirement of coverage and they've had that requirement going back in the past, then WSI can actually request the payroll up to 6 years in the past and calculate what premium should have been paid for that time frame. So in addition to the 6 years of premium, non-compliance penalties are also billed towards that overall cost. And the way that structure works is that for the most recent year of noncompliance, the penalty is 25% of the premium costs. And then for the next most recent year of noncompliance, that penalty increases to 30, and then 35, and all the way up to 50% of the premium costs. So those premiums and noncompliance penalties obviously can have a big impact, and you want to make sure you understand what the loss is and what your requirement of coverage is. Also, deductions from premium for wages or salary is illegal. So an employer can't deduct the cost of workers' compensation from their employees' wages or salary. Also, retaliation is prohibited. So an employer who prevents a worker from filing a claim or even discharges or threatens to discharge a worker for filing a claim, they can also be assessed penalties for that. Now, there's so much that goes into independent contractor or employee relationships and reviews, and every circumstance is different. So there's no blanketed statement that you could say one factor makes that determination. If you would like to discuss further and go over some of those intricacies of relationships you may be thinking about, please don't hesitate to reach out to me via phone or email. I'm happy to answer any questions you may have. Typically, when I present this, it's up to an hour long. So I know I've really only scratched the surface, but please don't hesitate to reach out if you have any questions at all or would like clarification.
Thanks, Sarah. We've got a number of questions, and I think my first question is, what are the three things that everybody on the call today should think about when they make this determination from a WSI standpoint?
First and foremost, again, is that presumption of employment. The workers are already presumed to be employees until proven independent. So that's a really big factor. Honestly, that's probably the biggest, most important thing. And just to ask those questions up front versus going years and years and years without determining whether or not your business has a requirement of coverage.
Statute of limitations could go back how far on premiums and injuries?
6 years.
6 years. Okay. Got a few questions here, then we'll move on to Pat Miller. How has the employees working from home changed the additional factors? IV COVID, a lot more people working at home. Are you seeing more use of ICs for those folks?
No, surprisingly not.
Okay. Are out-of-state independent contractor exemptions valid in North Dakota? So if I have a contractor exemption from Wisconsin or Montana and I come to North Dakota, does WSI recognize that? I assume that's what they're asking.
No, we do not. So out-of-state independent contractor exemptions are not valid in North Dakota just because every state has their own laws that they apply.
Okay. If workers register a business with the North Dakota Secretary of State, does that automatically make them a worker or a contractor?
No. We have seen some instances of businesses requiring workers to register their own business and obtain their own liability insurance in order to force an independent contractor relationship, if you will. And again, we're going to look at the relationship as a whole and how it operates, and not only the paperwork that's in place. Yeah.
Okay, I request to pop back to that slide with training in that list, and maybe we can just post that list as well. But if you want to pop back to that.
Sure, give me 1 second, please. Training, I believe this is the slide that you're looking for. The additional factors?
Yes.
Yes.
So kind of back to the old, who's telling you, who's controlling the work, when you work, who you work for, all of those things are, and really the direction of the work and all of those things are dictated typically by the employer, right?
Correct. And we do have some great information out on our website. It has links to statute. Also, it talks about all the different factors and all of these things that WSI is considering when making determinations is all in this. It's a front and back page of a brochure. So it is a great resource to print off and have. It is available on our website under Employers Resources.
Okay, we'll have Kristen try and find that and pop that in. A couple more questions. How many IC determinations does WSI do a year, and how many of those are related to oil and gas?
Well, obviously, with all of the things that have been happening in our world for the past 2 years, they've gone down. So they've gone from about 60 per year overall total in all industries to about, I would say, mid 40s the last 2 years. With being petroleum oil related, I would say about 15 to 20%.
Typically occurs, I imagine, when someone's hurt and there's nowhere for them to find relief.
Correct.
Okay. Is there a correlation to the cost of the premium and the use of ICs? If they're going to pay more, do they typically trend towards using ICs or not? In our case, probably to the price of oil.
Yeah, right. And it's surprising. No, another area that, or other areas that I perform independent contractor reviews in have a much lower or very low premium base. So I wouldn't say that there's a direct correlation to that.
Okay, any other questions pop in? We'll go back to Sarah at the end if there are questions for her. With that, Pat Miller is the expert in hand and a member at Sherman and Howard, and just a extremely knowledgeable ally of ours. So hi, Pat, welcome. We're ready for your presentation.
Great, thank you, Ron. Good to see everybody. So I would like to share my screen here. Oh, Kristen, it looks like I'm having trouble sharing my screen here.
If you shoot me your slide, I can stick it up there, Pat.
Yeah, I'll tell you what, I'll start with that. I'll go ahead and do that. So by way of introduction, my name is Pat Miller. I'm, as Ron said, I'm a member with Sherman and Howard's employment law group. And my area of practice is pretty much primarily occupational safety and health defense. So as Pat Nicodemus said at the beginning, I work with brokers like Tara and Pat to get connected with employers who are having issues with respect to occupational safety and health. I also do a little bit of general employment advice where it comes to FLSA, independent contractor versus employee issues. So certainly appreciate the opportunity here to talk about that issue. So I am going to, Kristen, send you this PowerPoint, and hopefully we can get that up. I will say on a personal note before we get going here that I have been a long time season ticket holder for Denver Pioneer Hockey, and I was very disappointed this year when it turns out that North Dakota was not going to be in our region for the regionals. Whenever you all come out, your fans come out, it's always a good time. So for those of you who are hockey fans out there, maybe we'll meet in the Frozen Four. So, and of course, here we go. Okay, Kristen, it should be coming your way here.
Okay, I'll have it up shortly.
All right, it's on its way. Sorry about that, everyone. For some reason, I'm not able to share on the Teams.
Pat, while you're waiting, I'll hit you with the same question. What are the three most common determinations in the IC status on the federal level?
Yeah, and I'll get into the specifics. Certainly, there's not as many factors as you have in North Dakota on the state level, but really the prime one is under the federal law is control. Who are you telling people what to do and when and where? To me, everything else is primarily secondary to that. And it's kind of interesting. It was great listening to Sarah's presentation because a lot of those, obviously there's a lot of the same factors that go into play there and in federal law. But really, and I'll talk about, and it's actually almost codified now in federal law, how it is that it's really control. If you tell somebody, again, when to be there, what to do, and probably most importantly, how to do it, that is really going to be what puts you in the employer category versus independent contractor. So Kristen, did you get those slides?
Yep, pulling it up now.
Okay, great. Thank you for doing that. So when the slides come up, I'll just give a little brief background of how the term employee has been interpreted in federal law. It's really interesting. Most federal laws and most state laws that I've run across in the various states contain little to no definition of what an employee is. The Occupational Safety and Health Act, for example, defines an employer as someone who employs an employee to work. Well, that's really not very helpful, is it? We don't know what that means to allow somebody to work. And that's really historically the traditional definition of employee is one who is an employer is one who suffers or permits someone to work. Well, that really doesn't get us very far in the analysis. So over the years, courts and Congress have kind of come up with varying ways to address this issue. And under federal law, there's really two directions. Sarah mentioned earlier that under Title VII and the Osha Act, for example, they use the Darden Factors. And the IRS uses the right to control test, which is very, very similar. And then the FLSA has its own test that I'll talk about here in a little bit. So, Kristen, if you could advance the slide, please.
Sorry, give me 1 second.
Mm-hmm.
Sorry. Getting it. Oh no, froze up on me. Okay, can you see now?
Yes, there we go.
Okay.
All right, so basically what happened, there was a famous Supreme Court case called Darden, obviously, where the Supreme Court decided the factors that federal courts look to under Title VII of the Civil Rights Act of 1964. And that's, as we're all aware, the statute that prohibits discrimination on the basis of all the protected characteristics we're used to talking about: age, sex, race, those sorts of things. So it's a long list, skill required generally, and Sarah talked a little bit about that as being a factor at some level in North Dakota. Source of the instrumentalities and tools, in other words, does the employer provide your tools, or do you have your own? Location of the work, Sarah touched on that. That one isn't, for the reasons she articulated, oftentimes a very big factor. Whether the hiring party can assign additional projects, that obviously that means, the more you control a person by telling them what to do beyond maybe what they were initially hired to do, that goes a long way toward someone being an employee. The extent of the hired party's discretion over when and how long to work, that's always been a big one under the Darden factor. If somebody can get the work they need to do done in an hour or two and can decide when they show up to do that work, that looks a lot more like an independent contractor than somebody who's told to punch a clock. Method of payment, Sarah mentioned, and I was curious to hear this because states differ, that the 1099 issue isn't a factor there in North Dakota. It is not only in terms of method of payment, but you'll see at the bottom of benefits and tax treatment. That is one factor. But again, I've never seen a case that uses the Darden factors in its analysis turn solely on the issue of whether it's 1099 or not. The hired party's role in hiring assistants, it sounds like that's a factor up there as well under state law. Whether work is part of the regular business of the hiring party. This kind of gets back to Sarah's example of the convenience store. If you're bringing somebody in to do something that isn't part of your normal business, making some repairs, fixing the AC, that sort of thing, that obviously goes a long way to showing independent contractor status or not. And then whether the hiring party is in business. Obviously, me as a homeowner, for example, bringing somebody to come in to fix something in my house, that obviously doesn't make them my employee because I'm not even in business. I'm just a homeowner. So those are the Darden factors, which again apply to claims under Title VII. Next slide, please, Sarah.
I only had those 3, Pat.
Oh, you do?
Yeah.
Huh. 1 second here. I don't know why the whole thing didn't go through, but let me. Okay. Try this one. I'm going to apologize for the technical difficulties, folks. So I want to talk while I'm sending the rest of the slides to Chris, and I want to talk about how other areas of federal law look at the Darden factors test. So, and the main one I want to talk about is Osha. Osha has adopted the Darden factors as what they will look at in determining whether or not somebody is an employee or an independent contractor. Now, there's 2 areas under Osha where this really comes up. One is in the traditional area that we've been talking about, where a company hires somebody that they truly believe is an independent contractor. And where we see this a lot are there 2 areas. They're landscaping and roofing. So for example, in landscaping, if somebody has a company that goes out and does lawns and things like that, but for some reason they need to have an excavation dug to maybe make a quick repair on a sprinkler line or something like that, they hire the excavator under the assumption that they're an independent contractor. Now, in those cases, say there's a trench collapse and the person digging the trench was injured or killed, what Osha will do is they will look at these Darden factors to decide if the hiring party is an employer for OSHA purposes. And while they look at all of those factors, the main one that OSHA looks at is control. That's why in response to Ron's question earlier, I said control, control, control. So basically what OSHA will do and what judges at the review commission will do in looking at these things, they will say, look, it may not be as dispositive as to who owns the tools. It may not be as dispositive as to whether it's 1099 or W-2'd. But what we really look at is, let's take the landscaping example. Does the party that's hiring the landscaper to come dig the excavation, do they control how, when, and where that person does it? And OSHA takes a very aggressive view here in making the determination that they are. I've had many cases with similar facts to the landscaping example, and almost invariably, OSHA takes a position that says, hey, if you tell them that you need this trench cut, even on a certain day, and you use that person consistently, even if that person works for other landscaping companies, for example, if they're kind of your go-to excavator and you call on them more often than not, say, OSHA will really determine then that person is an employee. And what's different a little bit than the system in North Dakota, obviously we're talking state versus federal law, but the way this gets decided under OSHA is that OSHA at the area office level, so in your case in Bismarck there at the OSHA office, they will just simply say, yeah, we think this person's an employee, we're going to issue the citation. And it's up to the employer then to contest and prove to an administrative law judge down the road that that person is not, in fact, an employee based on those Darden factors. So, so that's really the one area where it comes up. The second area where it comes up in OSHA, and this comes up in the MSA context, is where does OSHA think that your roustabout company or your other subcontractors on site, do they constitute your employees, even though there's more than one working for an individual company? So that one doesn't come up as much, though, because OSHA has, I'm sure we're all fairly familiar with it, what they call the multi-employer citation policy. So they don't have to, which means that they can pretty much cite everybody on the work site for one contractors or one owner operators or anyone along those chains violation of an OSHA standard. So so in that sense, it's not as important or helpful for an owner operator in the field to show that their subs are actually independent contractors, because even if that company is an independent contractor, and every MSA will say they are, for OSHA to cite kind of up the chain there under the multi-employer policy, they don't need to show that that person is an actual employee of the cited company. So again, the area where we usually get into it is where there's just the individual whose work is at issue in the independent contractor versus employee situation. Next slide, please, Sarah, or Kristen, excuse me. Okay, so that's Title VII and OSHA. And kind of a little bit of a backstory here historically. Cases that were decided under those Darden type of factors really didn't fit with what Congress wanted to do with the Fair Labor Standards Act. As you all know, the FLSA deals with overtime and minimum wage. And Congress was concerned that by having it too kind of open-ended and squishy like these factors kind of are, that too many people would be misclassified as independent contractors. So Congress actually established what we kind of call the economic realities test, or the Department of Labor has established this. And what this means, it's supposed to be a little bit more broad in terms of coverage. Basically, it wants to look at factors that show the overall economic reality of the work relationship that's going on. But you'll see in looking at some of these factors, they're very similar to the Darden factor. But look at the second factor there. That's very similar to what you have in North Dakota that Sarah described. The worker's opportunity for profit or loss depending on his or her managerial skill. So that's the same example as, is this person an entrepreneur? Do they take the risks? Do they get the big profits? Or are they essentially, as a matter of economic reality, punching a clock, doing hourly work, they're always going to make the same wage. The risk and reward factor really isn't there. So in terms of economic realities, that's always been one that they've relied heavily upon. Next slide, please, Kristen. So there's been a lot of development under this economic realities test. What happened during the Trump administration is the Department of Labor really said, look, these Darden factors, or excuse me, the economic realities test factors under the FLSA, and to some degree the Darden factors in other areas, are really making it difficult for employers to determine how to classify people. And I think we'd all agree that it's a mess. As Sarah described under state laws, I'm describing under federal law, it's just very, very difficult to put all these things together. So what the Trump administration DOL did is they put together an actual regulation that would provide clear, in its view, guidance as to when to classify as an employee versus an independent contractor. So much like North Dakota has those factors that it relies upon, that it weighs heavier, the federal reg has what they call core factors. And those two are the nature and degree of control, there again, over the work, which has always been a prime factor, both in economic realities and under Darden. And the one that both Sarah and I have spoken on, the worker's opportunity for profit or loss based on initiative and or investment. Are they in it to make money, or are they in it to make a wage? So this new standard, this new regulation says those are the core factors. Those are the two main things that employers should be looking at under the FLSA when determining employee versus independent contractor. And then 3 additional factors that if it's kind of a close call that employers can look at, the amount of skill required, the degree of permanence of the working relationship, and whether it's part of the integrated unit of production. We've touched on all of those. So next slide, please, Kristen. So where we are on this, and this is actually a timely topic, once President Biden was sworn into office, one of the first things he did at DOL was making moves to remove this, or at least delay the date at first of this regulation. So what it did is it went through and promulgated a rule, or thought they promulgated a rule, saying we're going to delay the implementation. Then they promulgated another rule saying, no, we're going to withdraw it. But that was challenged, and it was challenged on very technical grounds that the administration didn't follow the right steps under the Administrative Procedure Act, the APA. And just last week, a court in Texas held that the challengers were correct, that the Biden administration did not follow the Administrative Procedures Act. They didn't give enough time for notice and comment before withdrawing this rule. So as a result of that decision, that the core test that the Trump administration put on the books is still on the books. So for right now, under federal law, employers can look to those tests and those core factors in making this determination. However, what is likely, so the administration has 2 choices here. They can appeal that decision to the Fifth Circuit Court of Appeals, or they can just redo the process and go through the proper steps under the APA to revoke the rule. And most of us think that that's what they're going to do. So if I had to guess, I'd say within 6 months to a year, this rule is going to be gone, and we're going to be back to the good old economic realities test that has been confusing employers for decades now. So that's what I had here. Again, sorry for the technical difficulties. I don't know if we have any questions in the chat, Ron, but I really appreciate the opportunity to speak to you all, and hopefully we'll be able to do this in person one of these days.
Thanks, Pat. We've got two questions here. I think they're very unique. One is your traditional company man who's on the well site, runs the show, brings that vast expertise and knowledge of all of the services. Where's that person usually fall?
Yeah, that's a great question, Ron. The company man for Osha purposes is 10.5 times out of 10 going to be considered an employee. Usually, I mean, especially if they're living on site, if they're working exclusively for that outfit, I usually don't even, and usually it doesn't come up in the context of, are they protected under the Osha Act? It comes up under the situation is, can their action or inaction be imputed to the company? And more often than not, they can. That's why you're hiring these folks. They're the person in charge on site, and it's been my experience that it's now, it may be different for wage hour purposes, but as a matter of Osha law, I would say that that's going to be an uphill fight, saying that they're not covered by the provisions of the Act.
The other, I think, is a service or an office type employee that's working at home primarily for a company, fairly set schedule, been with that company for a long time, maybe has or not their own computer, doesn't really involved in, just is assigned tasks and they do it, but they've been doing it for the same company for a long time.
Yeah, I think this is one of the areas where in wage hour on the federal level, we've seen a big sea, I don't want to say sea change, but we've seen a lot of cases that are pose novel questions like this. So in that case, if she's been working for the same company forever, even though she has maybe a little more independence working from home now, it looks a little more like an IC situation where the employer says, hey, just get it done when you can type of thing. Employers run a great risk by thinking those folks are independent contractors. If they're the big factor in my view is she only working for the company? Now, if she truly has a specialized skill, say she's an accountant and is hired by different companies, does her work at home, runs her own books, that sort of thing, then I think it would be different. But we've seen a lot of employers during COVID and even now try and take the work from home situation and turn that into more of an IC relationship, and it just doesn't typically work.
Thanks, Pat. I think we could bring the WSI folks over, and probably where it's really going to get complicated is when during the day at home did that employee fall down the stairs, Sarah? Did they fall down the stairs during the regular work hours? Was it 15 minutes after the typical workday ends, right? That's going to get to be an interesting one. Right.
Yes, and we're going to look at, I was trying to figure out which Sarah you were speaking to. So it's a typical confusion between the two of us. But yeah, we're just going to look at that injury occurred in and out of the course of the employment.
Okay, anything else that either Sarah's has to add that we've missed? I think the determination is you should just really sit back and look at every situation and use the points that are provided on each side and make your determination, right?
Right, and if you have any questions, ask. There's no shame in asking questions and talking through the various scenarios.
Pat, we've got one other one here. If a company man is considered an employee, what action does the employer need to take? Just covering them on their workers' comp policy, I assume, and payroll taxes and all that stuff?
I would. Well, the tax issue is going to kind of depend, but for comp, and I'll speak for what the experience would be here in Colorado. I would defer to Sarah and the WSI folks up there, but for comp purposes, we have a similar structure here where if the company doesn't put the company man under their policy, then it's up to the company man to do it him or herself. So either way, ultimately the company would have to insure that. So my advice would be just put them under your policy, because if that person is not insured or underinsured, at least in Colorado, the company would have to kick in for comp anyway. So better to cover them at the front end.
And for North Dakota workers' comp, if that hiring firm is conceding that worker is an employee, they would just simply report them on their annual payroll filing.
One other question that I think, did we end up getting reciprocity with Montana on workers' comp? I know we fought that for a long time on the WSI side.
There is a 12-month approval for reciprocity, but it's a one-time 12-month approval.
Okay. Let's say that was probably a bigger topic 5 or 10 years ago when there was so much work going on both sides, because I know it was a huge issue. So thanks to all of you. We've got, this is a big topic and one that I think just more information is good. So this video will be put up on YouTube. Kristen will send it out to all the attendees, and it'll be on our in our e-news and on our executive speaker series. So with that, thanks for your expertise today. Glad that everybody could join us, and have a great week. Thank you.
Thanks, Ron.